Hadijatu Mani Karau was born to a mother who was a slave. In 1996, when she was just 12 years old, she was sold to the 46-year-old local chief, El Haj Suleiman Narua, for the sum of 240,000 CFA francs, which is about $500. This was in accordance with the Wahiyya or Sadaka practice in Niger Republic, under which a young girl is acquired as a slave to work as a servant, as well as concubine or fifth wife. Hadija too served her owner for 9 years, during which she had 2 children for him. She then extracted a letter of release from her owner with a promise to marry him, but then decided to marry someone else. The owner accused her of bigamy and she was put on trial. The matter went up to Niger Republic's Supreme Court, which failed to convict the owner in spite of the fact that the Nigerian Criminal Code had made slavery illegal in 2003. Hadijatu took her case to the ECOWAS Community Court of Justice. On the 27th of October 2008, the ECOWAS Community Court of Justice joined an external session in Niamey, Niger Republic, found the Republic of Niger in violation of the prohibition of slavery as set out under the African Charter of Human and People's Rights. The court ruled that the applicant Hadijatu Mani Korau had been a slave under the definition contained in Article 1, subsection 1 of the Slavery Convention of 1926, and that in failing to convict her former owner, the judicial authorities in Niger Republic had not upheld its legal responsibility to protect her from slavery under international law.
Hadijatu has been a victim of slavery and the Niger government is responsible for this.
In the courtroom, seeing the Prime Minister, the Speaker of the Parliament, and the Minister of Justice all sitting there to look at what was happening, attending the opening session of the court, I felt that it was already a success. For the first time in Niger, we will openly talk about a slavery system in the country. And the country will have now to face that praxis.
The Hadijatu case has become a locus classicus and a legal precedent for other courts in Niger Republic and West Africa, where several cases of slavery are now being determined by national courts.
The judiciary itself decided to adjust the whole legal system of the country to the decision of the court. Since then, you have at least hundreds of decisions from the lower court to the highest court about slavery. Any person who is slave now in Niger and who wants to go out from that system, you can use the court, to get what you want.
This is one of the most significant decisions of the ECOWAS Court of Justice. It was a pivotal point in the evolution of the court and its jurisprudence.
When the decision came out, it was not only in Niger, in West Africa, in the whole world, people talk about ECOWAS Court. It's like ECOWAS Court was something new in the world.
The Community Court of Justice came into formal existence in 1991 as the principal legal organ of the Economic Community of West African States, ECOWAS. Its initial mandate was the interpretation and application of the provisions of the Treaty of Lagos, which established ECOWAS on May 28, 1975, to promote economic integration in the region. It was clad with the status of an interstate court. This meant that the court could only rule on cases between ECOWAS member states or between member states and ECOWAS institutions. Community citizens could not approach the court directly with their grievances to seek judicial intervention. The pioneer judges were not sworn into office until 2001, and the court came into existence effectively, but it remained in limbo. Member states and institutions of the community who had the legal standing to approach the court did not do so.
For the first 10 years, it never really functioned. And when it did, it was on a staggered leg. It was not addressing the general need of the ECOWAS citizens because they were excluded from the jurisdiction of the court. And it only came to be after spirited effort by NGOs, the judges of the court, and all friends of the court.
Leaders of the West African Bar Association met with the management of the court to explore ways of making the court effective and functional. We went around the member states, made consultation with the various presidents, the attorneys general, ministers of justice, the ministers of integration, or rather the council of ministers. At the end of the day, the campaign succeeded.
Consequently, in 2005, there was a statutory intervention that led to a fundamental shift in the mandate of the Community Court of Justice. A supplementary protocol was adopted amending the 1991 Protocol on the Court. It expanded the jurisdiction of the court, investing it with 4 mandates. 1. As a community court. 2. As an ECOWAS Public Service Tribunal. 3. As a human rights court. And 4. As an arbitration tribunal. This is why it is sometimes called 4 courts in one. Most importantly, any individual with complaint of a human rights violation against state actors could approach the court directly.
If it had not come, I think the cases will still be trickling in, maybe 1 or 2 or 3 per year. And even those cases may have been cases that were wrongly filed, as the initial ones that were filed. Now, since 2005, that a supplementary protocol came and gave the court the human rights violation jurisdiction. And then the fact that individuals or corporate entities within the countries whose rights had been violated could come to the court, that is when the whole thing started. You see that from then the cases started rising and rising and rising. So to a very large extent, it has shaped the court's work and actually put more burden on the court.
Immediately that protocol was adopted in January 19, 2005. Before the end of that year, 6 cases had been lodged. The following year, 12. The next 24, and it has been progressing. We have about 160-something cases pending before the court. So the impact has been monumental.
I handled the first human rights case in the court. That is the case of Ebrimamane and the Republic of the Gambia, where a journalist was arrested and detained illegally. The court heard us and declared his arrest and detention illegal.
The supplementary protocol expressly vested the court with powers to determine cases of violation of human rights that occur in any member state. This has become the primary focus of the court, as aggrieved community citizens have taken to the Community Court of Justice to seek judicial redress. The heightened interest in the court is facilitated by its unique features, which make access to the court easy and the delivery of justice fast. It has direct jurisdiction, so aggrieved persons do not have to exhaust local remedies within their countries before coming to the court. The matter must, however, not be before another international court for adjudication. The filing process is not cumbersome. All it requires is a written application addressed to the registry with the name of the applicant, the party against whom the proceeding is being instituted, along with a brief statement of facts of the case and the relief being sought. The cost is minimal. The rule of procedure of the court is without complexities, and it does not dwell on technicalities.
The rules of procedure allows you to front load evidence, and sometimes all you need to do is possibly to file written statements that are sworn to by prospective witnesses. It is only in situations where there are contradictions that the court has the discretion of inviting oral testimony. So the court ordinarily can decide cases simply on documents before it. It saves a lot of time. The ECOWAS Court of Justice, sometimes, unless if they are very technical matters, within 6 months, within 3 months, as the case may be, the matters are decided and the case settled.
The court was one of the very first courts, at least one of the few courts in Africa to have moved proactively to facilitating access by ensuring that people could file processes electronically, services can be made electronically. So essentially, the practice direction, without being technical, is such that it facilitates access to the court. You can access the court from everywhere, and the technicalities involved in it have been reduced to the barest minimum. So the court is really very accessible.
From its seat in Abuja, the ECOWAS Court has been exercising its territorial jurisdiction, which extends over the 15 ECOWAS member states comprising of Benin, Burkina Faso, Cape Verde, Cote d'Ivoire, Gambia, Ghana, Guinea, Guinea-Bissau, Liberia, Mali, Niger, Nigeria, Senegal, Sierra Leone, and Togo. It has entertained a plethora of cases instituted by individuals over alleged infringements of a broad spectrum of human rights in the member states.
It is not an appellate court over the national court. Whether a district court or a high court or Supreme Court in a national court, they are in their own system and we are in our own system. And therefore, this court has taken its hands off cases that have gone through the whole trial gamut in the national court, and the person wants to come before us. It will be like you are coming for an appeal, and therefore the court will not entertain such a case.
The court has had to chart its own course as it adjudicated on critical subject matters that have had definitive effect on the region. Applicants have ranged from politically exposed persons to the ordinary community citizen. The Community Court of Justice has become the bastion of justice for those who believe their human rights have been trampled upon.
The ECOWAS Court of Justice is completely different. We are not restricted to any human rights system. We apply all international human rights treaties that member states have adopted. And because the member states in Article 4 of the ECOWAS Revised Treaty of 1993 made an undertaking to respect, promote, and protect human rights in accordance with the African Charter of Human and People's Rights. That is the basic text by reference that the court adopted as its Charter of Human Rights.
Flowing from its protocol, the Community Court of Justice also has a convention of holding external sessions in member states. Since its establishment, the court has held external sessions in Niamey in Niger Republic, Ouagadougou in Burkina Faso, Porto Novo in Benin Republic, Ibadan in Nigeria, Lomé in Togo, Bissau, Guinea-Bissau, Bamako in Mali, and Abidjan, Cote d'Ivoire. This is one of such sessions in Abidjan, Cote d'Ivoire. It brings the court closer to community citizens and further enhances access.
It offers an opportunity to bring justice to the grassroots of the community and to avail the community citizens the opportunity to observe the court session. It's also a very useful tool for creating awareness about the court, its mandates, competence, and judicial activities. Since the court has transited from ECOWAS of states to ECOWAS of people, it's pertinent that community citizens should know the ECOWAS Court of Justice and take ownership of it.
It's very interesting that the ECOWAS Court permits also to companies to have access to the court by violation of Article 14.
The procedure adopted in the court sessions here is a hybrid of physical and virtual hearing. It is part of the fallouts of the COVID-19 pandemic, which led to lockdowns around the world. For 3 months, the court could not sit. The wheel of justice came to a halt. To get the wheels turning again, the court embraced technology to enable virtual hearing. It has the added advantage of further easing access to the court and reducing associated costs. The practice direction has been amended consequentially.
La Cour a instauré le système des audiences virtuelles. Vous avez vu comme la conférence, par exemple, des gens restent chez eux et puis nous suivent. Donc c'est de la même façon que les audiences se passent aujourd'hui. Les avocats sont plus obligés de se déplacer de leur pays jusqu'à Abuja et peuvent se connecter et puis plaider devant la Cour.
As access has increased exponentially, the court has been seized with an increasing range of matters filed by community citizens. The judges have strived to deliver on their mandate, hearing cases and delivering well-reasoned judgments. Article 19, subsection 2 of the 1991 Protocol on the Community Court of Justice provides that the decisions of the court are final and immediately enforceable. The judgments of the Community Court of Justice have had profound political, social, economic, and legal ramifications for the region.
The court has declared, in fact, has annulled anti-media laws in Nigeria, in the Gambia. In Togo, the court has upheld the right of community citizens to access the internet, whereby the court declared that the government of the suspension of internet in Togo was illegal in the case of Amnesty International and Republic of Togo. Majority of the cases decided in the area of human rights have to do with illegal arrest and detention of citizens, community citizens. And the court has awarded damages. Unlike municipal laws, the court has upheld the right of community citizens, or rather, the socio-economic rights of citizens and the solidarity rights of community citizens have been upheld by the court.
E estas reparações são sempre em consequência da gravidade do fato ou da violação sofrida, dos prejuízos causados à vítima e ainda visando recolocar a vítima na posição em que se encontrasse antes da violação, promovendo a sua reabilitação, caso for necessário.
The pronouncements of the court have considerably enriched the jurisprudence on human rights in the region. Following the decision on Hadijatu versus Niger Republic, about 30 more cases have been decided upholding the prohibition of slavery in Niger Republic, relying on this precedent. Several other national courts are also being guided by the decisions of the Community Court of Justice.
The jurisprudence of the courts has become a pathway to the sub-region, to studies, to academicians, to students, to law practitioners. And it has become even relevant to other stakeholders outside the community.
I can say without any fear of contradiction that the ECOWAS court remains today the leading regional court in Africa. Its jurisprudence on human rights has elevated the promotion of human rights in the region, and that has impacted positively on the continent. The decisions of the ECOWAS Court are regularly cited, even outside the region.
L'impact d'une décision peut résulter de ce que l'État, par exemple, qui a été condamné, se rend compte qu'il est dans l'illégalité. Et donc, ces citoyens eux-mêmes se rendent compte que notre État vient d'être condamné par une juridiction internationale. Et évidemment, cela forge l'opinion publique.
The court has also succeeded in establishing an ECOWAS human rights mechanism with very unique features when compared with other regional human rights protection mechanisms.
There's no requirement for exhaustion of local remedies. You cannot come before international courts and tribunals without having exhausted local remedies in your municipal system. And in ECOWAS Court of Justice, there's no requirement for exhaustion of local remedies. So any violation in any member state can be brought the very next day.
And the idea, which I think the framers of this law had, which is excellent, is that in our parts of the world, as you know, a case can take 3, 4, 5, 6, 7, 10 years. So if a person, for instance, his property has been, like this hotel, has been grazed down, and he wants to go to court, do you expect him to go through the courts in the country who take another 10 years before, if he doesn't get justice, he comes to the ECOWAS court?
As the court commemorated its 20th anniversary in 2021, it was a significant threshold to reflect on its mandate and achievements. An international conference was organized in Lomé, capital of Togo, with the theme 20 Years of ECOWAS Court of Justice, Achievements, Challenges and Prospects. This is in line with the court's practice of holding international conferences over the years in diverse member states to enhance ECOWAS community law. Previous international conferences discussed a range of themes pertinent to the mandate of the court and the advancement of the legal system in the region. These range from protecting the rights of ECOWAS citizens to economic integration in West Africa, challenges and prospects. The 2021 International Conference focused on the performance of the court itself as the West African legal community, including judicial officers, jurists of international repute, scholars, and the civil society, converged to review its performance over the past 20 years.
It has reassured the citizen that there is now a court, an entity where they can go when they have issue about the interpretation of the rules, procedure, within the ECOWAS treaty and so on. You can see the number of cases that the court has listened and read. Decision made by the court shows that it has been extremely active. And then I think the second issue also that we need to raise is that the court has, of course, reassured the citizen. It is playing a very key role in the governing structure of the community. We must really compliment the court for the work that has been done. I think we don't realize it enough. We have a court that is well recognized in the continent. Is really a big achievement. It's one of the most successful courts and that we have on the continent, and a court that has really provided value added to the community agenda.
After 20 years, the Community Court continues to act as a beacon of regional peace, and we have already seen and heard how its decisions have led to myriad changes in law and practices across the West Africa sub-region.
Lorsqu'on n'est pas tellement d'accord ou lorsqu'on n'a pas tellement confiance, à tort ou à raison, dans le système judiciaire national, la Cour de justice de la CEDEAO peut venir à l'aide des justiciables et prononcer des décisions qui peuvent être importantes. Il arrive aussi que la question ne se pose pas simplement en termes de confiance à l'égard de la justice nationale, mais que par le hasard des procédures nationales, un justiciable se retrouve sans aucun recours Je pense à des personnes dont le dossier a été perdu, par exemple. Il nous a été amené de traiter des questions comme cela. Et lorsque la Cour est saisie dans ces conditions, elle peut essayer d'apporter dans l'arrêt qu'elle rend une satisfaction à la partie qui l'a saisie. Et donc je pense que, incontestablement, la Cour de justice de la CEDEAO exerce ce qu'on pourrait appeler une fonction cathartique, c'est-à-dire une fonction consistant à faire baisser une tension née d'un litige.
I strongly believe that the ECOWAS Code is one of the strong mechanisms for maintaining peace in West Africa.
The ECOWAS Code stands for stability. It helps to stabilize the region, helps to stabilize government. Because once people are not able to get justice in their countries and they're able to get it in the place, they are satisfied and they go home without much problems. But if they are not able to go home and the anger keep bottling up, and you have about 10, 15 cases or more of that type of thing, it can grouse insurrection.
The overwhelming concern was, however, the non-compliance of member states with judgments of the Community Court of Justice. All countries are required to appoint focal persons who will be responsible for the enforcement of decisions of the court. Only 6 countries have complied. Over the years, only about 30% of its decisions have been implemented by member states. This flies in the face of the combined effect of provisions of Article 15, subsection 4 of the ECOWAS revised treaty and Article 2, subsection 1 of the supplementary protocol, which makes the judgments of the court binding on all the member states, the institutions of the community, individuals and corporate bodies. Article 19, Section 2 of the Protocol on the Community Court of Justice also provides that the decisions of the court are final and immediately enforceable. Article 24, Section 2 and 3 of the Supplementary Protocol of the ECOWAS Court expressly provides for the method of enforcement of the court's judgments through a writ of execution to be submitted by the registrar of the court to the relevant member state for execution according to the rules of civil procedure of that member state. Upon the verification of the appointed authority of the recipient member state that the writ is from the court, the writ shall be enforced. The Community Court of Justice itself also pronounced in the case of Musa Saidi Khan versus the Republic of Gambia that it is untenable for a member state of ECOWAS to claim that a matter is essentially within its domestic jurisdiction when it had expressly or by necessary implication granted ECOWAS powers to act solely or concurrently with national jurisdiction in respect of that matter.
Sadly, this is not the case. State actors now decide which ruling or opinion of the court to honor. This does not just undermine the integrity of the court, but creates a serious reputational risk for ECOWAS.
As decisões dos tribunais não são apenas para serem proferidas e permanecerem literalmente como uma peça, diria, doutrinária. As decisões dos tribunais têm que produzir os seus efeitos e só podem produzir os seus efeitos na sequência da execução. Portanto, se o tribunal reconhece a violação de um direito humano de um determinado indivíduo e lhe oferece meios de reparação à violação do seu direito, obviamente que se tal não for executado, apesar do tribunal ter reconhecido a violação do seu direito humano, nada, portanto, muda relativamente a essa vítima, portanto, que ficará apenas com o reconhecimento de que efetivamente foi objeto de uma violação de direito humano.
Some former presidents who had contempt for the decisions of the court when they were in power, or rather, who refused to comply with valid and subsisting decisions of the court, have had cause to seek legal redress in the court when they find themselves out of office. Some of them include former President Laurent Gbagbo of Côte d'Ivoire, former President Mamadou Tanja of Niger Republic, former President Yaya Boni of Benin Republic, and even former President Charles Taylor of Liberia.
Nonetheless, the judgments continue to have a life of their own in member states.
Even if the decision is not immediately implemented, but for the judiciary in our countries, when they see the decision, they said, this is the reference, this is the standard that we need to apply.
A judgment against the government of Liberia based on a case filed by the former head of state, his wife, President Doe's wife, former First Lady. She got a judgment, $18 million. That judgment has not been complied with by the Liberian government. Another judgment, the judgment against Liberian government based on a case filed by Justice Kabina Jane, who was unlawfully impeached by the Liberian government. That judgment also has not been complied with. The failure of the government to comply with these two judgments had made the issue of the ECOWAS Code highly discussed in Liberia, and therefore public awareness is growing about the ECOWAS Code.
When the court gives its decisions, whether they comply with it or not, we serve them.
The court is also contending with another challenge. As part of the institutional reforms of ECOWAS, the number of judges was reduced from 7 to 5, while their tenure was reduced to 4 years, non-renewable. This is coming at a time when the burden of cases before the court has become very heavy.
The African Court is 6 years renewable. The East African Court is 5 years renewable. The International Criminal Court is 9 years. So there is no international court that has the kind of aberration in terms of the tenure of the judges like the ECOWAS. 4 years non-renewable. Now, why is that a concern? The work of the judge and the composite closure of the court is such that you don't get into the system and immediately get a grasp of all. Even if you've been a judge in your national court, it's not the same as being a judge in the ECOWAS court, because the processes, the instruments, the precedents are different. So you do actually need a stabilizing period.
La Cour de la CEDEAO, qui est une grande cour, et tout le monde le sait maintenant par ses décisions, elle s'est fait respecter, elle s'est imposée au plan international. Ce n'est pas au moment où cette cour-là est en train de faire ses progrès qu'il faut la ramener en arrière. Donc nous allons mettre dans les recommandations qu'il faut ramener le nombre de juges à 7, qu'il faut aussi revoir le mandat des juges. Les juges viennent ensemble et partent ensemble. Donc la Cour n'a pas de mémoire. Il faut voir, il faut aménager le système de sorte que quand une équipe vient, qu'elle ne part pas ensemble. Au moins que quelques-uns restent pour recevoir les nouveaux qui vont arriver. Mais sinon, quand vous faites dans une maison, vous videz tout le monde et puis vous mettez de nouvelles personnes, c'est un peu difficile à gérer. Or, la Cour a besoin de mémoire, la Cour a besoin de transmettre à l'équipe qui arrive l'expérience acquise.
Nonetheless, the Community Court is strengthening its institutional capacity to administer justice to the community. It is introducing more technology-driven innovations to enhance contemporary administration of court processes. It has developed a transformative electronic case management system. It will set a new paradigm in case management.
ECMS has 2 modules. The first one is dedicated for case management, is the back end of the application, and is being used by the ECOWAS staff. The second module is the external portal, which is dedicated to the lawyers and people filing from remote locations in front of the court. And the purpose of having that is to fully digitize the court processes of the ECOWAS court. On the external portal of ECMS, it gives the possibility to lawyers from member states to register in front of the court. To register, they will need to provide 3 things. The first one is a proof of identification. The second one is to provide a proof of practice in their member state. And finally, they will need an email address. When they have that, then they can go on the portal and click on the button register. When they click on the button register, it will give an interface where they can provide all the requested information, meaning an electronic copy of the eligibility document, an electronic copy of their ID or passport, their address, the city where they live, and their phone number. Cases are created automatically. There's a workflow. If the application is approved, then a new case number is automatically allocated to that case. From the initiating application to the treatment of the application, all the way to the decision and the publication on the website, the process is fully digitized. With that, it's purely for the benefits of the citizens of the member state. It will reduce the cost of the procedures, and then it will reduce the time of the procedures.
The court has also a vision to extend its jurisdiction to matters relating to the original goal of ECOWAS, which is the economic integration of the region. This will open up a new vista in line with the contemporary concerns of existential challenges of the West African community.
ECOWAS is more or less a customs union. If you look at the protocol on free movement, you understand, free movement. You look at the ETLS, economic trade, the ECOWAS trade liberalization scheme. You look at the protocol on common external tariff. We properly achieve the status of a customs union as it were. But individuals don't have access. Non-state actors don't have access to the court in respect of those instruments, and that is the main challenge.
The objective is to make the people feel part of the court. The court belongs to them.